On March 29, 2025, Philip Lloyd was charged on a multi-count felony complaint following an encounter with Officer Zach Rezacuenta of the Romulus Police Department. The charges include felon in possession of a firearm, carrying a concealed weapon, and possession of a firearm while under the influence. Officer Rezacuenta received a dispatch call on 1 a.m. in the morning by an alleged harassment at a gas station. The prosecution contends that the officer observed Mr. Lloyd walking away and initiated a contact that eventually revealed a firearm and an outstanding warrant. However, the defense has moved to suppress the evidence, arguing that the encounter was an unlawful investigatory detention from its inception. Defense counsel Andrew Martin asserts that the interaction constituted a seizure under the Fourth Amendment. The defense maintains that the officer's verbal commands and show of authority created an environment where a reasonable person would not feel free to terminate the encounter. The hearing was held before Judge Brian A. Oakley in the 34th District Court of Romulus, Michigan. The state called their first witness, Officer Rezacuenta, to the stand. After the direct examination of prosecutor Stephen Kaplan, Mr. Martin had the opportunity to cross-examine the officer.
Good morning, Officer Spuna. Morning. So a few questions for you. Just briefly, you say as of now you've been a police officer for about a year and a half.
That's correct.
So as of March 29th, 2025, the day of this incident, how recently had you become a police officer?
So I graduated the academy on November 11th.
November 11th of 2024.
Correct.
Thank you. And then immediately you joined the Romulus Police Department? Okay. And then as of that time, you mentioned that in your career you've done more than 5 drunk driving investigations. How many do you think you had done as of March 29th, 2025?
I'm not sure.
So, as you just confirm what you stated on direct, you're dispatched to this location, the gas station, but at that point you had not spoken to any employee or citizen who was at the gas station, right?
That is correct.
And the information you received from dispatch, it didn't describe crime taking place at the gas station. Wouldn't you agree?
I was dispatched to a male harassing customers at a gas station.
Harassing. But that's not a report of an assault, right?
Correct.
Not a report of trespassing.
Correct.
And you didn't have any more detail beyond the word harassing. So you and your partner pull up to this gas station in a fully marked patrol car.
Correct.
You and your partner are both fully uniformed.
Correct.
And as soon as you pull up, you and your partner hop out of the car.
Step out of the car.
Step out of the car. And you immediately see the person later identified as Mr. Lloyd outside the gas station.
That's correct.
You never go in the gas station.
That's correct.
And there's no one else outside, right?
That's correct.
So you don't see him interacting with any other person.
At the time, that is correct.
You don't see him committing anything that would be called harassment. And you don't observe any sort of, bulge consistent with a firearm at that time when you first see him, right?
That is correct.
Okay. And you see him, but you didn't recognize him from any prior interaction, no?
I did not recognize him.
Okay. And as soon as you see him, would you agree that your words to him were, "What's going on? Come here." And so at that point, you've given him an official order to come towards you, right?
I would say so, yes.
Yes. He's not free to leave at that point, right?
In the circumstances, I would say yes.
Thank you. And this is at the point where you're giving him that order, you don't yet know this person's name, right?
Right.
You don't know anything about what he has warrants. You don't know anything about intoxication.
Correct.
Right.
So we
And
can follow.
when you say those words, "Hey, come here," his body at that moment, he was kind of walking away from the front door of the gas station. Would you agree?
That's correct.
Okay. Safe to say he was not approaching you when you made that order, right?
Correct.
Okay. But then as soon as you make that order, he submitted to your order and came to you and your partner, right? At that point, you began questioning or interviewing some kind of. And so when you eventually discover this firearm, that's due to a search incident to arrest on the warrants, right?
Yes.
Okay, it's not some sort of, you don't perform a Terry frisk prior to arresting him on the warrants. You never performed any sort of field sobriety tests on him, right?
That is correct.
No breathalyzer.
Correct.
And no blood draw that you're aware of.
Correct.
I have nothing to
Mr. Martin argues that Officer Rezacuenta's failure to conduct even a cursory investigation indicates that the detention was not based on reasonable suspicion. Under the reasonable suspicion standard, reasonable suspicion requires specific facts that would lead a reasonable officer to believe that criminal activity may be occurring. The standard demands more than an unparticularized hunch, but less than the level of certainty required for probable cause. Mr. Martin confronts the officer's inexperience by the time he was a law enforcement and the lack of conducting a proper investigation in the scene. Under Michigan Penal Code 750.411, harassment means conduct directed toward a victim that includes, but is not limited to, repeated or continuing unconsented contact that would cause a reasonable individual to suffer emotional distress, and that actually causes the victim to suffer emotional distress. By acknowledging that Mr. Lloyd was alone when approached, Officer Rezacuenta confirms Mr. Martin's speculation of the lack of reasonable suspicion. The moment Officer Rezacuenta issued the command and the defendant stopped, a seizure occurred as a matter of law. The officer conceded that Mr. Lloyd was not free to leave and had submitted to his show of authority. Mr. Lloyd, walking away from the storefront, conduct that is entirely innocuous and does not provide a nexus to criminal activity.
Any defense witnesses? I'm ready for argument, fellas.
Notice, we always do, we didn't present any proofs regarding felon and possession of firearms. It's not as lost down. Yes, we all proofs. Without going into large details here, we don't have proof at this point to show that the gentleman, Mr. Lloyd, was a felon in possession of firearms. We asked Your Honor to bind the case over on 2 counts. We know it's unusual and misdemeanor, but carrying a concealed weapon and possession of firearm while under the influence of liquor, that's a 90-day misdemeanor. So what do we have here? We have an officer on patrol with a partner wearing a uniform and a marked scout car, and he receives a call from dispatch. Now that is very common. That's how they communicate. Dispatch says there's a guy at the gas station harassing people, something along those lines. And a description is given, not only of the gentleman's race, but his height and what he's wearing. Officer arrives, sees a guy, one guy, not 100, not 50. He sees the defendant. Defendant is outside. It's close enough to him at some point to see he's under the influence of liquor. Now, Terry v. Ohio allows an officer to stop, detain, and question a person when there's reasonable suspicion that he might have committed a crime, attempted to commit a crime, or is about to commit a crime. And at this point, at 1 a.m, they see a man who allegedly has been harassing people. They have a right to investigate. He asked them a simple question: "What is your name? What is your name?" And he doesn't have a licensed judge, but finally he says, "It's Philip Lloyd." And guess what? Mr. Lloyd has warrants against him. So they arrest him, they search him, they find the guns. There's no Fourth Amendment violation there. We seek a minor vote.
Mr. Martin.
Thank you, Judge. So first, to address what Mr. Kaplan just said about some of these counts, they're now looking to bind over on 1, 2, 4, or 5. So of course, defense moves for dismissal of those counts.
Done.
Furthermore, I'd like to address the added count next, this proposed misdemeanor, which Your Honor did allow Mr. Kaplan to ask questions regarding that count on his exam. So if I may offer some counter argument, even Mr. Kaplan having the opportunity to make a record of this misdemeanor count, the only record he made is possible observations of suspected intoxication in a case where there's no field sobriety tests, no breath, no blood. I mean, we're speculating here. This isn't a driving case, so those things wouldn't exist. So this person has never met Mr. Lloyd before, doesn't know his disposition, doesn't know anything about his mental health. So I think that we're grasping at straws here, and that count should not be bound over. Now, finally, if I can turn to the remaining felony CCW count, where we are objecting to bind over on Fourth Amendment grounds, as Mr. Kaplan alluded to, I believe that there is a Fourth Amendment violation here. If I can just explain what that looks like, I think that the controlling case here would be the California versus Hodari T case from the Supreme Court. That citation is 499 U.S. 621. That's a 1991 case written by Justice Scalia. And that's really the case that stands for the proposition that when does a seizure occur? If an officer has not used physical force on someone, if an officer gives an order that says, "Hey, you stop," and that person runs away, that person has not been seized for Fourth Amendment purposes. But if an officer gives an order, says, hey, you stop, and it's a lawful order, the person then submits to that show of authority, that is the moment of seizure for Fourth Amendment purposes. It's really a question of, does this person feel free to leave in that situation? We even had Officer Sakuna agreeing that once he's given a lawful order to Mr. Lloyd, that Mr. Lloyd is not free to leave. So let's think about what is known to the officer at the time when he gives that order, that seizure. He doesn't know Mr. Lloyd's name, doesn't know anything about Mr. Lloyd having a warrant referred to. Terry versus Ohio would require reasonable suspicion that Mr. Lloyd is armed and dangerous at that time. And we had testimony that there was no observation of any sort of firearm-shaped bulge. So there's nothing in the report to say, hey, this man is harassing people and he has a gun. There's nothing like that. So there's no reasonable suspicion that he's armed. And I think that alone should cause it to fail. How many Terry cases have you seen where it's based on suspicion that a person has a gun? That suspicion did not exist here until he's being searched incident to arrest on these warrants that were, again, unknown at the time of this Fourth Amendment seizure. So that's why I do believe there's a Fourth Amendment problem here, and that the evidence seized, namely the firearm, is the fruit of a Fourth Amendment violation, and therefore the case should not be bound over. Thank you, Chuck.
You're welcome.
Mr. Martin asserts that a Fourth Amendment seizure determination must be predicated on the exact moment a defendant submits to an officer's show of authority. This framework, established under California versus Hodari D. and adopted by Michigan jurisprudence in People versus Mayman, defines a seizure as occurring the moment a subject yields to an officer's assertion of power. Under the standard of Terry versus Ohio, police officer may stop a suspect on the street and frisk him or her without probable cause to arrest if the police officer has a reasonable suspicion that the person has committed, is committing, or is about to commit a crime. Mr. Martin reinforces lack of reasonable suspicion by the officer Rezaquenta occurred by a failed investigation of the scene. A vague dispatch call regarding a suspicious person is a conclusory allegation, and without independent corroboration of criminal activity cannot justify a warrantless seizure. Mr. Kaplan argues the encounter remained consensual until the discovery of outstanding warrants. However, prosecution acknowledged a procedural deficit regarding the felon in possession charge, conceding a lack of a certified record of conviction. Consequently, the state moved to bind the defendant over only on carrying a concealed weapon in possession of a firearm while under the influence. Finally, the defense challenges the evidentiary foundation for the intoxication charge. Under Michigan law, under the influence requires a showing of substantial impairment. The defense notes the record is devoid of objective forensic data, such as field sobriety tests or preliminary breath tests. Without these tests, the officer's subjective impressions constitute mere speculation, failing to meet the probable cause standard required to bind the defendant over for trial on the intoxication count.
So I too am familiar with California versus Hodari D. And in that case, there's a young man, a young male, the police see him, he sees them, and he runs away. This defendant runs away, and the police run after him. And the court says, there's no seizure. There's no seizure. He ran away. Now, in this case, I'd like you to imagine we live in a world where under these circumstances, an officer has to say, oh, I see this guy. He matches the description of somebody who allegedly was innocent people at the gas station, and I can't do anything about it. Hey, nice to see you, officer. Nice uniform. Have a good life. That's not the case. The police have a right to investigate. It's 1 a.m. There's a harassment call. There can only be one guy. He matches the description. If he can't say, oh, hey, come here, what's your name? I don't want to live in that world, because that would mean that many of the arrests that the officers made, many of the collars they made, many of the stops, they're not good. They're not good. This case involves reasonable suspicion based on the time of the day, the actions of the defendant, and I'm not even sure asking somebody's name is a inquisitorial matter. We all have a name, and you ask them his name.
I'll give you another shot.
I would say we're thinking about, how do we avoid a situation where every single interaction like this is a Fourth Amendment violation? Well, a police officer in that situation can arrive at the scene and do more to investigate before they start telling people to come to them and implying that they're not free to leave. Obviously, the officers could have entered the gas station first, tried to find out who made this call and learn some more information. Instead, they see a single person, gives him an order, and at that point start investigating. when they've learned nothing about what happened. So I think that they went about this wrong.
I just want to make sure I understand the argument, Mr. Martin. Because I think what your argument is that based on what they got from dispatch alone, they did not have enough to investigate the gentleman they saw outside the station.
If you think about, my argument is when they say, hey, come here, that is a seizure for Fourth Amendment purposes.
I think we would all, I don't think you're disagreeing to that, are you?
No.
Well, I think we all agree that was a seizure.
That's a seizure.
Yeah.
So what's the lowest standard in Fourth Amendment law?
Right.
Reasonable suspicion. So is there reasonable suspicion at that time? So if it's, and there's reasonable suspicion for Terry's purposes, that's armed and dangerous, I don't think that's met.
I would agree.
For reasonable suspicion also appears in the traffic stop context, reasonable suspicion of a traffic violation. That's obviously not present here. Reasonable suspicion of a crime, I don't think that's relevant either. And in fact, that's.
Hold on. Let me stop you there because I think we all agree that's where we disagree. You think there was reasonable suspicion of a crime triggered at that point. You don't. Am I right?
I would modify someone reasonable.
Go ahead.
Had committed a crime, attempted to commit a crime, or is about to commit a crime.
Fair enough. Do we agree that's where the split is between you two?
I agree with that.
Okay, go ahead then.
One more piece of law on the record.
Sure.
I'm sorry, I didn't have this at the ready, but there is a piece of Michigan law, I'm trying to find the correct MCL, that talks about the circumstances where an officer is authorized to make an arrest. And while I'm fumbling for the exact citation right now, it is when circumstances where there's no warrant, there's a piece of Michigan law that says that an officer may arrest when a felony or misdemeanor is committed in their presence, or if they have reason to believe that a misdemeanor of a certain severity was committed even outside of their presence. And under that law, I don't think that the standard is met here either.
I would agree with you. Yeah, I think the question is whether or not, based on the dispatch call only, they had a reasonable suspicion. Because you don't think they do without more investigation before they seize.
I agree. I think it'd be different if the dispatch call said he's intimidating other customers and making them feel unsafe. I mean, that might be reasonable suspicion of some sort of assault or threat, or he's been told to leave and he's not leaving, reasonable suspicion of a trespass. But this scant amount of detail, and we don't have dispatch records. I mean, they could have brought in the CAD report from the 911 call and have someone authenticate that. I don't even have that in discovery. So we're just not going off of enough here. When you're making someone feel not safe to leave, well, just go into the gas station, talk to the clerk, learn some more information first. So then you're doing this investigation based on personal knowledge and not just stopping people on the street based on this extremely undetailed, unspecific report that you got through a dispatch.
Mr. Kaplan,
If we accept,
I'm loving this, by the way, so I thank you both.
he doesn't have to stay, but we say, stay here, we're gonna investigate what happened in the gas station, that would be a seizure. That's not what happened here. When you put on your rope this morning, you didn't leave your common sense behind. The fact is, it would be misconduct on the part of the officer to say, hey, I'm leaving. I have other things to do. I want to stop at Dunkin' Donuts. That would be misconduct in office. He probably would lose his job if he just said, let it go. He has to investigate in the way he did. Hey, what's your name? How incriminating is what's your name? How many of us have outstanding warrants as this man did? He's the one with the warrants. He's the one who didn't show up at court. He's the one where the officers have to arrest him when they learn about him.
Mr. Martin contends that the dispatch call failed the indicia of reliability test. In other words, to specify if it was an assault or trespass or any type of repeated or continuing unconsented contact. The officers engaged Mr. Lloyd without performing a threshold investigation. Because the dispatch call was a conclusory allegation rather than a report of specific observed criminal acts, it required independent corroboration that Officer Rezaquenta admitted was absent. According to Article 1, Section 11 of the Michigan Constitution, this threshold is dispositive. It dictates whether the officer possessed reasonable articulable suspicion, an objective basis for suspecting criminal activity, or if the interaction was merely a consensual encounter. In a consensual encounter, an officer may approach a citizen to request identification. However, the citizen retains his freedom to terminate the interaction. Once a seizure is initiated, the officer must point to specific facts justifying the detention. While Mr. Kaplan points to the totality of the circumstances, the defense maintains that these factors are circumstances of geography and time, not evidence of individual guilt. By moving directly to a seizure without establishing a nexus between the defendant and a specific crime, the police violated the constitutional protections against unreasonable search and seizure, rendering any subsequently discovered evidence fruit of the poisonous tree.
Right, thank you, gentlemen. I'm going to bind over on count 3 only. I understand your argument, Mr. Martin, that the dispatch call that there's a black male wearing a black hoodie and black pants that's been harassing customers is not enough detail, but I think it is enough detail for an investigation. And I don't think an investigation that starts with "what's your name" is onerous. So I'm gonna bind over only on count 3. I agree with your argument on the under the influence carrying a weapon.
Judge Oakley proceeded in the charge of carrying a concealed weapon, but dismissed both a felon in possession of a firearm and possession of a firearm while under the influence due to a lack of enough evidence for the last 2 counts. Judge Oakley ruled that the dispatch call regarding the harassment of customers provided a sufficient factual narrative to initiate a lawful investigation. Regarding the specific charges, Judge Oakley found that the evidence presented did not meet the probable cause standard for the weapon-related counts. Specifically, he declined to bind over the charge of carrying a weapon while under the influence, suggesting a lack of evidence regarding the defendant's state of sobriety or the possession itself. So far, Mr. Lloyd was released on bond conditions. This case illustrates the critical importance of the Fourth Amendment protections during police-citizen encounters and the judiciary's role in curbing investigative overreach. Mr. Martin reinforced the lack of reasonable facts to stop Mr. Lloyd constituted an unlawful seizure. Judge Oakley, on the other hand, determined the first counts would be dismissed by the lack of sufficient evidence, but would keep the count of carrying a concealed weapon. By distinguishing between a truly consensual interaction and a command backed by a show of authority, the court reinforced a fundamental principle of criminal procedure, that an officer's directive constitutes a stop that must be predicated on specific, articulable facts of criminal activity and not merely suspicion. The suppression of the firearm highlights the fruit of the poisonous tree doctrine, confirming that evidence obtained through an initial constitutional violation cannot be used to sustain a criminal charge. Ultimately, the resulting dismissal reflects the court's recognition that the integrity of the legal process depends on law enforcement's adherence to the free-to-leave standard. This outcome underscores the vital function of preliminary proceedings and motions practice in safeguarding defendants' rights and ensuring that the Fourth Amendment remains a meaningful check on state power. Now, let us know if there is a case you would like us to explore in the comments below. Thank you for watching, and don't forget to like and subscribe so that we can help promote a more informed society.